Good evening, everyone. Thank you for joining us for the webinar, Hot Topics in Physician Immigration with Elissa, Taub. While everyone's still logging on, I just wanted to take a minute to introduce myself. My name is Peyton Jennings, and I am the Physician Engagement Coordinator here at Practice Match. A lot of you attending might already know me because I work closely with the attendees from the virtual career fairs. Since you're here tonight, you already know a little bit about Practice Match and all that we have to offer physicians. If not, I'll just highlight a few of the resources that we have to offer for you. We have a free CV builder, we have scholarships, the virtual career fairs, the webinars like you're attending tonight. We have a free copy of the free physician immigration handbook, which Elissa can tell you more about, or the free immigration handbook, and she can tell you more about the immigration handbook. So if you have any of those questions, feel free to reach out to me. If you have any questions throughout this webinar, please put them in the Q&A or the chat box, and we will get to them as quick as we see them. Note that microphones will be muted throughout this session, but again, please put any questions in the chat or Q&A box. Lisa, whenever you're ready, you can go ahead.
Great. Thanks so much, Peyton. It is great to be here with you all tonight. As Peyton mentioned, my name is Elissa Taub. I am a partner with the immigration law firm Siskin Susser and co-author of the Physician Immigration Handbook. This is the 2023 edition, which is yellow, and it's pretty big. So has a lot to do with physician immigration, everything from the beginning of the process, from when you arrive here in the United States, all the way up through citizenship and all of the steps in between. So if you're interested in a copy, talk to Practice Match and they can hook you up with a free copy of the book. Tonight, we're going to do a little bit different of a webinar than what I normally do. Usually I pick a topic and we kind of do a deep dive on some immigration related topic. There's so much happening right now that I thought it might be better for October as we start this new fiscal year to do more of a hot topics program on lots of different topics that relate to physician immigration. So we're going to jump around and kind of talk about a lot of different things tonight. A few just basic housekeeping things. You are more than welcome to ask questions. I do a really good job of monitoring the chat and the Q&A during the webinar. So if a question does come up, please feel free to put it in there at any time, and I will monitor those boxes so that hopefully I can answer your question close in time to when we talk about that topic. So it's at the most relevant point of the conversation. If you don't remember, it's okay. We'll have time at the end for questions, and that's totally fine. And also, given the nature of the presentation tonight, I'm not going to really be doing a primer on immigration matters. In other words, we're not going to talk about a lot of the basics and get into detail on like, what is a J-1 waiver and how does the process work? Because we're going to be talking about hot topics and what's going on with J-1 waivers right now. So if there are things that maybe I go over that I'm not kind of giving you a deep dive on it so that we can cover everything in the time we have. And then the final thing is we may not go a full hour tonight, which is totally fine. I'm sure you all are really busy and have a lot of things going on, but we have that time available if we need it. But we may come in just under that time frame, and which is fine. But I just want to give you, if you have to hop off early, you may not miss anything. So let's get started talking about hot topics, and let's see if I can get this to advance. Yay. So tonight we're going to cover a variety of topics. We're going to skip around and talk about a bunch of immigration related issues. We're going to talk about them with how they relate to physician immigration specifically. The first topic we're going to go over is the impact of a potential government shutdown. I'm not going to talk about, certain issues that don't relate to physician immigration with regard to that, right? We're going to focus in pretty heavily. We're going to talk about J-1 waiver updates since the fiscal year just started. We'll talk about the green card backlog, and then I'm going to give you some updates from around the federal agencies that we most commonly deal with on physician immigration matters. So USCIS, the Department of Labor, and the Department of State. So we'll cover all of those topics in tonight's webinar. So let's dive in and talk about a potential government shutdown. Now, you might be saying, Elissa, the government didn't shut down. Like, that was all this past weekend. You're late. Like, didn't you read the news? And the problem is that, yes, I have read the news and have been following the news today. And the prospect of a government shutdown is not off the table. In fact, it is still very much a potential reality. It's just not going to happen right now. So I'm going to go back. I want to do a little bit of a review on why we almost had a government shutdown this weekend and why that risk is still not off the table. And then we'll talk about what the impacts of that shutdown might be for us. The reason we almost had a shutdown is because you might recall, and we've talked about the federal fiscal year in a lot of these presentations, right? We all know the federal fiscal year starts October 1st. What that means is that the US government's 2024 year started on Sunday. In order for the government to be funded as the new fiscal year begins, Congress has to pass a law allocating funds amongst all of the different government agencies and programs so the government can operate. And they usually pass that budget, they pass the law that's going to provide those funds before the end of the year on September 30th. This year, unfortunately, by the time we got to September 30th, Congress had not yet passed that budget. And to kind of give you an idea of like how things work in the US Congress, all appropriations bills, meaning all bills that provide federal funding for programming, start in the House of Representatives, not in the Senate, right? Those are our two houses of Congress. The House of Representatives, which has a majority Republican party, the Speaker of the House was Kevin McCarthy. They did not pass a budget by the time we got to September 30th. But what happened was on the Senate side, there was a lot of worry about what would happen if the government shut down. So the Senate came to a compromise. They passed a compromise bill, sent it back over to the House, and the House ended up passing that compromise bill. But that compromise bill that passed on late Saturday night that the president signed only funds the government through November 17th. So we averted a government shutdown this weekend. The federal government is still open. There is some funding for programming and for things that need to occur as necessities at the federal level, but only through November 17th. So we're going to go through all of this again over the next 30 to 45 days. And the added challenge is that today, the House of Representatives voted to recall Kevin McCarthy as the Speaker of the House. The Speaker of the House is the leader of the majority party in the House of Representatives, and that leader is largely responsible for setting the House of Representatives legislative agenda, what laws that are going to be brought up to be voted on and potentially passed. Without a Speaker of the House, it's unclear how the House is going to do business. I don't know, and I know media outlets today were talking about this. In my lifetime, I don't think this has ever happened. Certainly, I don't know if a speaker has ever been recalled midterm in the history of the United States. So it's a little unclear what's going to happen from here. So the likelihood of a government shutdown on November 17th is still pretty high. I'm worried about it. Our office is still going to be operating as if this is a real possibility that the government's going to shut down. And so we'll just need to kind of wait and see what happens. But I think it's really, for all of these reasons, it's really important for us to review, well, what could happen if the government shuts down and what won't happen if the government shuts down, so that you can have an understanding of what might be on the horizon. And then if everything works out and the government stays open, we just wasted 10 minutes of talking about it, but that's okay. At least we were prepared. So what will happen? The Department of Homeland Security, which is the parent agency for USCIS and CBP, will stay open. USCIS is entirely funded by the fees that you or your employer pay to them to file applications. They are not fully funded by government appropriations. And for that reason, they won't run out of money at the end of any fiscal year, any fiscal appropriations. So USCIS will continue operating as normal. This means that your adjustment of status application that is pending, your H-1B petition that is pending, your I-140 that is pending, all of those things we'll still be able to file. We will still be able to get adjudications of those cases in the event of a shutdown. CBP will continue operating. If you have travel plans, you will be able to enter the United States. It won't be like all of the immigration stations at the airport will be empty. There will be CBP officers there. They will be getting paid. Airline travel becomes a little bit weird because the TSA will not be paid, even though they are still being required to show up for work. So the TSA are all the security folks at the airport that man all the, or they staff all of the x-ray machines and all of that stuff. We have seen in past shutdowns that they get very slow. They'll have sick outs. People will stop showing up to work. So operationally, flying might be a little tough, right? You're going to have to leave extra time at the airport, but the immigration aspect of entering the United States will continue to operate. The Department of State is a mixed bag of sorts. They will continue to stay open. The agency will operate. Consular affairs typically are not fully impacted right away by a shutdown, but over time, as funding might recede or become more, start to run out, you might see consular staff having to be furloughed, like on a rotating basis. And so we may see consular posts that have to lay people off for a little while and maybe cancel appointments or spread out appointments and not take as many because they don't have the staff available for them. So we'll have to see how that goes. The Department of State's function in adjudicating J-1 waivers should also largely go ahead unaffected. We pay $120 per case that we file with the Department of State. That should fund that operation or the handling of those applications. Again, if rolling furloughs become an issue, we may see that process slow down, but I don't recall an interruption in J-1 waiver processing the last time we saw a shutdown, so we should be okay there. And in case you're wondering, the last time the US government shut down was in 2018 and it lasted 35 days, and that was the longest ever. Up until, I forget what year it was, but it wasn't that long ago, we had never had a shutdown, right? So this is a modern construct. So things kind of can evolve and change each time this happens. But I expect Department of State operations from where we all sit, hopefully we will not see too much disruption. One thing I'm not really sure about, to be quite honest, is what happens to our federal agencies that handle J-1 waivers. My thinking is that HHS likely would shut down for a period of time, or at least that it might be subject to a furlough. In other words, the government may not tell them all to go home, but they may have to go home in shifts, right? A week here, a week there. So we'll have to see how that goes. The DRA and the ARC used to charge filing fees for their waivers, and they no longer do. So in the past, they never stopped operating because their programs were fee funded. Because they're not fee funded any longer, I don't know what their plan is in the event of a shutdown. They might continue to operate at least for some period of time while they still have funding, or they may shut down, and we're going to have to wait and see what happens with those two agencies. The SCRC, the Southeast Crescent Regional Commission, which is our newest J-1 waiver agency, they still charge a $3,000 filing fee for those cases. And I tend to think that they will continue to operate as normal in the face of a shutdown. So the HHS, DRA, and ARC, not entirely clear what happens with those. SCRC, I tend to think will continue operating as normal. And that's our hope, of course. All right. So next issue. Okay. The big thing, though, the big story in the event of a shutdown is what happens at the U.S. Department of Labor. This, from my immigration law practice and the clients that I serve, this is the biggest, most impactful shutdown that occurs anytime the government shuts down. The Department of Labor will shut down. The Department of Labor is responsible for handling the LCAs that accompany all H-1B petitions. They also issue prevailing wages that are relevant to PERM applications and Schedule A applications that we file for nurses and PTs, and they adjudicate PERMs. So the preliminary step in the green card process for most folks who are being sponsored by their employer. They have a huge role to play in our ability to file petitions with USCIS. The Department of Labor has said they are going to shut down their flag portal in the event of a shutdown. This means that not only won't we be able to file any of these applications or get adjudications of any of these applications, we won't even be able to access the portal where they sit. So we've been printing out approved cases and even drafts of cases to make sure that we have them on hand in the event of a shutdown. There have been some past shutdowns where USCIS has said, we'll accept H-1B filings even if you just have a draft of an LCA. But the challenge is if we can't even draft an LCA in flag, we can't, like, what are we supposed to do with that? We don't know. There's no answer to that yet. So while USCIS's operations are going to be unaffected by a potential government shutdown, the Department of Labor's shutdown could impact the ability to file certain petitions with USCIS. And the other thing I'm a little concerned about with that is that right now, if you're, the beneficiary of a perm application, these things are taking a long time. They're taking a long time to be filed because prevailing wages are taking a long time, and then the perms are taking a long time. the Department of Labor is currently working on cases that were filed October last year, right? So we're already at nearly a year of processing. This shutdown is not going to make that any faster, right? They're not going to get new cases during the shutdown. But the ones that are there, nothing's going to happen with them for as long as the government is shut. So we're a little worried about the impact on government processing times from a shutdown at the Department of Labor. So that's why I said that is the most impactful part of a government shutdown from my perspective, is what could happen. So hopefully we will avert it, on the next the next go around. But it is certainly something that if you have anything in the works, you have a waiver, you have an H-1B, you have a green card, anything that's being filed that might have to go through the Department of Labor, definitely important to pay close attention to the shutdown, and see what happens, because it's important. There's nothing we can do about it, right? Like if the Department of Labor shuts down, it shuts down. There's no going to, you can go to your congressman and say, hey, open the government back up. This is ridiculous, but there's no expediting, right? The people are all home. They're not working. So that could be a really big deal. So that is our government shutdown topic. We're going to now switch gears and talk about J-1 waiver updates. Most J-1 waiver programs are open now, that we are in the 2024 fiscal year. The only state I know of that's not open right now, I think, is Ohio. That's pretty normal. A lot of years they don't even open until January. So they're still working on their rules and things like that. Notably, Texas is already closed for the year. They received upwards, I think, like 38 applications, something like that, in their filing period in early September. So they are closed, and that process is already over. And that's pretty typical. Texas usually does not last past the middle of September. I checked in with the Indiana Department of Health today. They have 32 applications already. Their program opened on September 1st. Some of those applications were rollovers from last year, of cases that weren't supported last year. And then others of those were filed already in early September. My office shipped out 2 applications on September 1st for their program. So Indiana will still remain open to accept primary care applications until they get 35 or they reach December 31st. But just like every other state, they can only support 30 waivers. So those primary care kind of go to the front of the line before all the specialists, kind of after the rollover for the specialists. So primary care applications could still work out in Indiana. But if you're a specialist looking for a waiver in Indiana, this is probably not the year for you, given where they are already in their numbers. Couple other things to note about other states. California, right before the fiscal year was supposed to open, radically changed their processing. In past years, they wouldn't allow specialists to file waivers until July. So basically after completion of fellowship. This year, about 4 weeks before the program opened, they said they would accept all comers on October 1st. So our office scrambled to get an application together. They also said that they would only take applications from locations that are in HPSA underserved areas or MUAs that were redesignated in the last 4 years, and there are none of those in the entire state. They relented on that part, at least for this year, but they've advised that if employers are in an MUA and not in an HPSA in terms of their underserved designation, that they should reach out to the state and see about getting that designation re-upped so that they might be able to qualify next year. So big changes in California. I don't know how many waivers they've received so far this year. I think they're still processing what came in. Maine opened on Monday. We filed a case there, and they've already reached out to us and told us to submit the second stage of our application, which tells me we were in the first 30. I don't know how many were filed overall, but you can see that, some of these first come, first served states are open and accepting applications. There are a bunch of states with October 31st and late November, early December deadlines. So those filings are ongoing. So there's a lot going on in J1 waiver world right now. We became aware of a potential change in policy with HHS today. And there are a lot of open questions about it. But there are some HPSA designations around the country that if you look them up, it says it's proposed for withdrawal. And HHS forever has agreed to support waivers in those areas. They announced today or this week that they would not do so. We've already filed applications that are in areas that are proposed for withdrawal. I literally learned this in the last couple of hours. So we're trying to find out more about what that means. And one of the organizations of which I'm a member has reached out to HHS for some clarifications on cases that were already filed and what to do, because this was a late breaking development that was not previously announced. So you can see there's a lot happening J1 waiver wise. There was a question in the chat about J1 waivers for positions that are 7 on, 7 off, and whether if you work somewhere in your off days that's not underserved, whether that impacts your ability to comply with the waiver or with the PNIW. So only if your waiver was done. Well, a couple of things. If your J1 waiver includes all of those locations and is done as a flex waiver, you're fine. If it's not, and your waiver is just based on the underserved location, then so long as you're working full-time in that underserved area, if you moonlight in a non-underserved area, that should be okay. In the past, USCIS has not really split hairs about that. With regard to the PNIW, a similar rule is true. You can only get credit toward a PNIW for time spent working full-time in an underserved location. You can't do a flex for a PNIW, and you can't get credit for working in a non-underserved area. But doing so won't upend your eligibility for the PNIW. In other words, if your 160 hours a month are still in the underserved area, and you're working, in moonlighting in a non-underserved area, it shouldn't impact your ability to qualify for a PNIW. And there's another question here about international travel once a waiver application has been submitted. My general recommendation is that once the initial agency that supports your waiver recommends it and your waiver is logged in at the U.S. Department of State, that at that point, you do not travel internationally. And this is especially true if you're going to need to visa stamp while you're abroad. It can complicate your ability to obtain a J1 visa stamp if your waiver is already supported by the Department of State, right? It's the same agency. So I tend to say, look, once the Department of State has your waiver, the best practice is not to travel at that point. Travel won't necessarily interrupt the waiver. It's more that the waiver application could interrupt your ability to come back to the United States, and we want to avoid that if possible. Okay, so that's my general J1 waiver update. A few important things to note. And of course, the programs are all open. Everything's in operation. So it's the same rule for, I say it's the same rule for Canadians, even though you don't have to visa stamp there. If CBP sees in the system that you have a waiver that's been recommended by the Department of State, it's possible they can give you a hard time at the border. The risk might be low. I can't forbid you to travel. There's no law that says not to. It's just not advisable, in my opinion, to travel once the Department of State has your waiver. Okay. So let's see. Next thing, green card backlogs. Yay. Oh, everybody's favorite topic. Not really. So This is a really challenging topic because in addition to understanding what's happening right now, everybody always wants to know my opinion on what might happen next month. And I will tell you right off the bat, I have no idea. I study the Visa Bulletin very closely. I have for a long time. I stay up to date with it, and I check it pretty much the day it comes out every month. I'm also not great at math. So I don't go behind the scenes and do my own deep dive calculations to try to approximate what might happen. And I don't really know anybody who does, because it's really challenging to get at that data. I can only go based on what I read and based on kind of my sense about how things are. One of the things that's happening right now is that when the October Visa Bulletin came out in the middle of September, it did not do what a lot of us expected it to do. We expected EB2 worldwide to become current or close to current again. We expected the EB3 worldwide category to move ahead pretty far. Neither one of those things happened. We expected the categories for India that are pretty far backlogged, especially EB1. I expected that to move pretty far ahead, maybe not become current, but get to a more reasonable place. And we thought that EB2 and EB3 would sort of rebound to a certain point in the year. And they didn't do that. They didn't move as far as we thought they might, because the beginning of the fiscal year, the October Visa Bulletin should be the most optimistic Visa Bulletin of the year. It's when all of the green cards that are, for the coming year are available. Everything's on the table in October. So if we don't move fully far ahead in October, we get a little nervous about what's going on inventory wide, supply and demand wide. However, USCIS came out with some statements the same day that the Visa Bulletin came out. And I kind of, before I read their statements, I kind of had an idea of what was going on with this retrogression, with this backward movement in the Visa Bulletin. And my thinking is, and USCIS kind of bore this out with its comments, which is they have a lot of inventory. The Visa Bulletin changes in 2020 that caused us to be able to file thousands and thousands of adjustment applications for long backlogged folks. A lot of those cases are still pending, unfortunately. And then they've had all the cases that have come in the years since, right? So since 2020, all of these other cases have been filed as the Visa Bulletin has moved forward and back and forward and back. I think that they were afraid that if the Visa Bulletin really moved super far ahead for this month, that they would get deluged with all kinds of applications again, and it would just be a mess, right? It was a mess in 2020. It took them 6 months to issue receipts on countless cases. I mean, it was ridiculous. I think they know that they can't handle that kind of deluge, and they were trying to dissuade folks, kind of keep folks from being able to file. And because they have such big inventory, they could reasonably say, well, we have enough cases to, what did they say? Something like, they have enough cases for India and China to not only meet the statutory allotment of visas for this year, but for the next several years as well. So they could say, well, we're not going to really move the bulletin that much. We're going to tell the Department of State, look, we don't have capacity for this. Does that mean that we're going to stay at these numbers and things aren't going to move ahead? No, that is not what that means. And so even though October is usually the most optimistic time of the year for the Visa Bulletin, I also think there's some metering going on. In other words, the government is trying to control the influx of applications so they don't get so backed up again, and they could keep their processing times in line. So we may see incremental movement over the course of the next however many months of this fiscal year that allows us to file in a more measured fashion instead of it being like a fire hose of filings like it was in 2020. If you look at the filing dates chart on the October Visa Bulletin, that gives you an idea of right now where the government thinks this fiscal year is going to end up. But as we all know, that shifts and moves around as well. So that's not the final word on the story. This month, USCIS allowed us to use the filing dates chart to submit adjustment of status applications. So you also know that if they're trying to keep the fire hose down to a minimum, right, and not have that deluge, that didn't go maybe as far as it could have. So at the risk of being too rose-colored glasses on this, I do think we are going to see forward movement in the Visa Bulletin this year. Can I tell you how far? 100% no. I have no idea. I think it will be small increments. Could I be wrong? Could we get a November visa bulletin that is just completely bonkers? Yeah. I don't expect that. I do expect measured movement in our ability to file adjustment applications this year. The days are behind us when there was a glut of green cards due to COVID, and everybody and their brother could file adjustment applications because the visa bulletin moved ahead however many years. That is done. It's done for now. I don't know the next time that might happen again. But for right now, we're in a scarcity situation, and you have a lot of cases pending at the government and a smaller number of green cards available. And that is not, even I, who am really bad at math, know that that's not it's not a positive calculation there, right? Doesn't help us. So that's where we are with the green card backlogs. And I think the important thing also to remember with all of this is, usually when we talk about green card backlogs, everybody who's not from India or China kind of turns off. They're like, oh, it doesn't affect me. I don't need to worry about that. Right now, it affects everybody. There is even EB2 worldwide, there is a backlog, which means that we cannot concurrently file physician national interest waiver applications. For folks who are going to work 5 years in an underserved area, I can file the I-140s all day long, but I can't file the adjustments at the same time like we used to because of this backlog. So that's no longer, we used to do that to get spouses green cards. Now what we're doing is we're filing the PNAW with premium processing and using that I-140 approval to get an H4 EAD for the spouse instead of an adjustment-based EAD like we used to. We've had a major shift in strategy on that. So the visa bulletin is forcing us to file in certain ways applications that we maybe didn't do previously. For everybody, not just for Indian nationals. So H4 EADs have become a bigger deal for non-Indian nationals than they used to, because we used to do the adjustment EADs. Just some food for thought on that. It's I don't know when that might abate. So right now, I think it's important to know. And I think, to be honest with you, I think a lot of Indian national folks for a long time have felt like they're on an island dealing with some of this backlog stuff on their own. Nobody else really was paying attention. Now it affects everybody. So everybody needs to be in tune with what's going on with the visa bulletin. Everybody needs to start to understand these issues, because this is going to persist for a while, and maybe exacerbate as we go. Okay. I just wanted to make a note because I thought about an issue to cover on the last slide. So that's the green card backlog. And now we'll move on to agency updates. Ooh, last slide. Yay. Okay. As you all know, if you've been following U.S. immigration updates for any length of time, things change. They don't necessarily change from Congress, right? We don't see law changes, but we see policy changes. We see, from the most mundane things like where to file a case, to really impactful policy changes that either help people or make life more difficult, right? So always seeing agency updates. Tonight, we'll talk about updates from USCIS, the Department of Labor, and the Department of State. Each of whom have important information to share. So we'll start with USCIS, and there's actually couple of things that I didn't put on the slide that I'm going to talk about as well with them. Okay, H4 processing. Before 2017, if I filed an H-1B petition with premium processing, and at the same time, concurrently, I filed an H-4, USCIS, as a courtesy, when they approve the H-1B, would also approve the H-4. Can't premium process H-4s by themselves. The I-539 form that they're filed on is not eligible yet for premium processing for most categories. In around 2018, the Trump administration stopped that courtesy, and they split up the H-1Bs and the H-4s. And H-4s during COVID were taking like 15 months to be approved. So we'd have an H-1B spouse with a fully approved application, working, no problem. And the H-4 spouse couldn't even get a driver's license because the application was still pending a year or more later. It was ridiculous. There were lawsuits. USCIS ended up settling a major lawsuit and agreed in that settlement to revert back to the old policy. And they've largely been doing that since January of this year. It's been wonderful. It feels like old times where, everybody's happy. The H-4s are getting approved. But there were some cases where USCIS started splitting them up again and saying, yeah, we know there was that legal settlement, but we're not bound by it for you, and we're not going to do it. Too bad. Just recently, in the last week or so, actually it was last week, USC affirmed that they are going to abide by that court settlement, and they will commit to the concurrent adjudication of H-1Bs and H-4s where they are filed together and the H-1B is premium processed. I will be honest, I have not had this problem in my office. Hopefully that continues, but I have colleagues who I know well who have been fighting this fight. So I'm glad to know that USCIS is going to abide by a legal settlement and continue that concurrent processing of H-4s. It is super helpful for families, it doesn't require people to travel unnecessarily and be sitting without a driver's license, stuck at home, and all of that. So it's really a good policy. Also, just recently this week, USCIS has stopped requiring biometrics for filers of I-539s. Prior to 2021, between 2018 and 2021, USCIS was requiring biometrics of anybody who filed an I-539, H-4, O3, J-2, like anybody. In May of 2021, I believe they got rid of that policy and said that suspension for H-4s and other assorted folks, the suspension of biometrics would go until September 30th, 2023, which was Saturday. USCIS has now revoked the biometrics requirement for all I-539 filers. That means even if you're applying for O3, you're applying for B1, B2, you're applying for J2 or F1 or whatever it is that you're filing that I-539 for, there is no longer a required biometrics fee. And in fact, it was either yesterday or today that USCIS officially updated its fee list online to take away the biometrics fee from that form entirely. So the biometrics for I-539s are now a thing of the past. So if you apply for an H-4, you shouldn't have to go for fingerprinting. It is a good thing. It's the way things used to be. So we are back to kind of like the old style of processing H-4s and other I-539 applications. I mentioned on the slide customer service phone line frustration. USCIS has updated its phone line and the voicemail system that you have to go through to get to a person, and it is maddeningly frustrating. I've had it hang up on me. I've had it threaten to hang up on me if I ask for an agent one more time. It is not a friendly AI. So just a word of caution, if you need to call USCIS for something, you might not get a person on the line. Emma, the online chatbot, also can lead you to a person. Emma can be helpful for certain things, but not for others. But sometimes if you are getting frustrated with the phone system like I do and are yelling not safe for work words at the AI on the phone, you might try Emma just to calm down for a little while and then maybe try the phone again. That's how I do it. Sometimes I get through to a person on the phone and then they can be actually pretty helpful. But just getting through that voicemail system is hugely challenging. We believe, and USCIS has said, and we don't know when it's coming, but there is going to be a new H-1B cap regulation coming soon that is going to affect the way the H-1B cap is going to be held in March of 2024. I don't know anything about what's going to be in the regulation. We are waiting for it. We believe it's coming this month. And it should hopefully help make that lottery system fairer than what it has been, because it's just been kind of a nightmare, to be honest. So I see the question in the Q&A. We'll get to that at the end of the presentation. So the new H-1B cap regulation, like I said, I don't know exactly what it's going to be in it, but I do know it's coming. And the hope is that it's going to make it fair, maybe cut down on the folks filing so many registrations with different jobs that they accept, that it makes it really hard for a person with a single job offer, who's really committed to that position, to get picked in the lottery and actually go forward with that cap H-1B. So we'll see what's on the horizon with that. Two other USCIS changes that have come in the last week, one including today. USCIS has started issuing EADs with a term of 5 years for people who have filed adjustment of status applications and other types of EADs based on like asylum and stuff. Does not apply to H-4 EADs, which are still tied to the validity of the H-1B. Does not apply to TPS EADs, but it does apply to asylum-based EADs and adjustment-based EADs, regardless of the basis for your adjustment. So whether it's family-based, whether it's employment-based, doesn't matter the category. As of now, if you file an adjustment application with an I-765, you are going to get a 5-year EAD. This is huge because before they were coming for a year or two at a time, and we were constantly having to extend them, and it was taking USCIS forever to extend them. And USCIS said, you know what? This is silly. We'll just issue the EADs for 5 years, and then hopefully most people will get their green cards in that time and not need to file an extension. And that's the hope. So really good news there. We're happy about it. It actually cuts down on some of the work that we have to do as well. So we're always happy to have more time in our day. And the last thing happened today, USCIS updated the filing locations for a whole slew of I-129s, including for O1s and Ps, Qs, and Rs. This might not impact you specifically because you're not filing your own case. Usually your lawyer is, but it's interesting to me because they're all being sent to the Texas Service Center. And I understand that that service center has massive scanning capabilities and is uniquely qualified to get cases into USCIS's Ellis system. So what this is telling me is that USCIS might be preparing to get these cases digitized, and that might allow for easier consular processing because they might get into PIMS faster, maybe easier to work with, and they might start showing up in our USCIS online accounts, maybe allowing for more information to be available online about those filings. So stay tuned. I don't know that for sure, but the fact that all of these cases are now being filed at Texas to me is a sign of what's to come, and it's very, very interesting. So those are my USCIS updates. Can't remember. Oh, DOL. Earlier this year, the Department of Labor unveiled a brand new ETA 9089, which is the application form that we use for perm labor certification filings. The new form was not, what's the right way to say this? It was not well done. It was rushed. It felt like it was rushed out. We attorneys did not have a long time to get acquainted with it before it went live. We are now using it to file. I have filed a ton of cases using it. I still don't like it. It makes me nervous. And I'm not going to see cases adjudicated based on this new form until sometime in 2024. USCI, or the Department of Labor, is still handling cases that were filed last year on the old form. And they haven't set up the training protocols yet to train their officers on how to file on the new form, or how to adjudicate the new form when it comes up next year. So what this tells me is at some point in 2024, perm processing times are going to lengthen more than they already are. As the Department of Labor trains its officers on adjudicating the new form, and as officers start having to read through this new form, understanding the way the questions are asked now, which is hugely different than the way the questions were asked before, looking for information that's no longer required to be included on the form, but always was before, and different information that's now being included that wasn't before. So it's going to be, I expect it's going to be a little messy for perm adjudications. The hard part is that the Department of Labor, as we talked about earlier, they don't charge filing fees. They're not allowed to. There's no statutory or regulatory authority for them to charge fees. So there is no premium processing. There is no congressional expedite. They don't have any expedite procedures. They say they do everything first in, first out, which isn't literal. It used to be. It is not right now, but it's close to it. So, the worst part about all of this is the waiting. The only thing we can do is wait to hear back. So this is your caution that perm processing probably isn't getting better in the next year. So where it is now is bad. It is slow, and it is going to remain slow for the foreseeable future. But I always like to end on a good note. So the Department of State, they are still planning to roll out a pilot program on the stateside renewal of visas. That means being able to renew your visa stamp from inside the US. It is not live yet. I am going to repeat that. The program is coming. It is not live yet. You cannot currently renew or apply for a US visa from inside the United States. Even if you were selected for interview waiver at the consulate and you get an email that tells you to mail in your passport, if you're in the United States, you should not do that, because how are you going to pick up your passport at the embassy? They are not going to mail it back to you in the US. You have to be abroad to apply for a visa right now. There is going to be a small pilot program that is going to be unveiled at some point soon, I think. Don't know exactly when, that is going to allow some people to renew their visas in the United States. It is likely going to be very limited to get started. I don't know the parameters. The Department of State has not unveiled those yet. I know they're still working on technical issues with the process, but they're going to try it out for a period of time or for a certain number of visas. Then it's going to stop. And then they're going to hopefully roll it back out again for a wider use. So stay tuned on that. Not a thing yet, but it's coming. In the meantime, the State Department continues to tell us that third country national processing is available. So if you're having a hard time getting an appointment in your home country, you can go anywhere else in the world where you can get an appointment. One of the challenges that we're seeing is a lot of consular posts are not allowing the scheduling of third country national applications because they are required to prioritize applications or interview or appointments for people who live in the country where they're located. So even though the Department of State is like, you can process anywhere, a lot of the posts are pulling back to service only the people who are in those countries. So it's still a thing. If you find an appointment, take it. You know, I would still say to kind of look and see where you can get in. But it isn't, the availability of third country national processing is not opening up consular appointments the way that maybe we all thought it might when they first started allowing it, because the individual posts are limiting who can schedule appointments, or, you know, maybe per month they're only allowing a handful of third country national appointments and then leaving the rest open for the home country people. So it's a well-intentioned policy, but it's not necessarily panning out the way we were hoping. So that is the Department of State. And that is the last agency update that I have, but I want to get to this question regarding, let's see, somebody who's pending an asylum interview, but is becoming a board certified physician, and whether it's a good idea to apply for an NIW. What I would actually recommend, applying for a green card while you're in the asylum process can be quite complex. The rules that apply in that context can be different depending on where you're located in the United States and what federal circuit court covers where you live, because there are some differences in the way that the government handles those cases around the country. It also depends on how you entered the United States, how long you waited to file your asylum application, how long that application has been pending. So the method of applying for the green card, whether it's through an employer sponsorship or through an EB-1 or an EB-2 NIW, that's less important than the fact that you probably would have to process that green card from abroad through the consular processing application, as opposed to being able to adjust from inside the United States. But there are a lot of questions that would need to be dealt with. So I would definitely recommend that as the type of question you definitely would need to talk one-on-one with an attorney about, because there are just a lot of considerations that go into that. So sorry, I couldn't just give you an easy answer to that question, but it is pretty complicated. Let's see. But thank you all for those great questions and for your attention. And I'm happy to answer additional questions in some time that we have remaining. And I see that one just popped up. Yes, you are correct. The Physician National Interest Waiver, or PNIW, is a green card application that is available to somebody who agrees to work and then actually does work for 5 years in an underserved area. The PERM pathway, which is an employer-sponsored green card, does not require any underserved service. totally different calculation. There we're looking at whether there are American workers available for your job. So it's totally different. The PNIW is something that you can sponsor yourself for. So that's one of the big differences also between those two applications.
There is, I saw 2 questions in the chat box.
Oh, there we go. Yeah, thanks. I didn't see that notification. Okay, so yes, an employer can start a green card process for you before you start work for them. It is a prospective looking, forward looking process based on an offer of employment that will come, that you'll take once you get your green card. So yes, right now, green card processing, if you're not on a J1 and the process is started for you, I would say somewhere around 2-3 years to receive your green card if you're not born in India. If your employer goes bankrupt or if you're laid off, let's say, doesn't have to be a bankruptcy, but if you do lose your job while you're in H-1B status, you have a grace period of up to 60 days from your last day of work to find another employer and for that employer to file an H-1B transfer for you. So it's a maximum of 60 days for you, or during those 60 days, you theoretically could file a petition to change your immigration status to B1, B2 visitor status while you continue to look for a job if that's something that might be necessary. So it's up to 60 days in between jobs. And so with regard to telehealth, there's a question about telemedicine. For J1 waivers, telehealth is a little bit complicated. I know, for example, that California, I believe, will not support a waiver for a doctor who solely engages in telemedicine. It's an open question at the federal level whether a solely telehealth position can qualify for a waiver. I have worked with some doctors where telemedicine was part of their waiver job and it's been okay, but they also were working primarily in an underserved location, or we did it as a flex waiver if they weren't, and it kind of worked out okay. But it's an open question, and I think it will depend on the waiver program that you apply to, whether a telehealth position can work. Now, years ago, I did work with some doctors who were entirely telehealth. They didn't have J1 waivers, but they were reviewing like sleep scans or eye scans or whatever, and we were able to get them green cards through the PERM process and get them H1Bs, and that was totally fine. The issue with telehealth really comes into play in the J1 waiver context. And how you comply with that underserved service and the patient care, like exactly what you're doing in that telehealth may matter for that analysis. You can apply, you can start the green card process while you're in your 3 years of J1 waiver service. There's a question about this. You can't receive your green card until your 3 years are up. So you kind of file that last step of the green card process once your 3 years are up. Every employer has different policies about what they will support when it comes to green card sponsorship. So while you can start the green card process during your 3 years of service, if it's the employer's policy not to start that until you complete all 3 years, they're not doing something illegal. It's their prerogative. If they're going to be paying for that process and they're sponsoring it, it's something that they can say, no, we want to make sure that you stay and that we've retained you beyond those initial 3 years to get started on that process. Is it the most employee friendly policy? Well, no, but it's not a wrong policy for them to say that, even though they could start the process now. Let's see, then we have another question. Oh, I love this question. How soon does one need to start a job hunt for 2025 on a J1 and things to look out for? Thank you for answering that question, or for asking that question. My opinion, it is never too early to start looking for a job. I actually have done 3 or 4 consults with doctors who are 2025, and I have one who's already signed a contract. Of course, we're not starting on his waiver yet. We're going to file that next year. You are not behind, but you're not too early. Usually I start talking with doctors about waivers for the following year in like February, March, April. That's usually when my next year's consults really start in earnest. So if you're starting to make contact with recruiters now, if you're starting to use practice matches tools to look for a job now, maybe attending some career fairs or things like that, This is a great time to do that and start navigating your job search. Your waiver application is going to be filed around this time next year. And if you're a 2025 candidate, which means that you're going to need to sign a contract, a good 4 to 6 weeks before that minimum. So, if you're signing a contract next summer or next spring, that means that you already need to have been talking with recruiters and starting site visits and things like that. So prime time, go for it. I would not wait. Let's see. Oh, one more. So somebody asked a question about how long you need to work with an employer before they sponsor you for a green card. And that kind of dovetails with the question I answered earlier. By law, an employer can start that green card process for you at any time, even before you start working there. That doesn't mean that they have to do that. They may have their own internal policies about when to start that process. They might say that you need to work for them for 90 days, 6 months, a year, 2 years. There was a question earlier for somebody who said their employer wanted them to wait the full 3-year J1 waiver service to start that process. So your employer might have a set policy. And if they're treating everybody the same and they're kind of doing that same, having that same wait period for most of their employees, then that's okay. That they're not starting it at the earliest possible time. As you can imagine, from an employer's perspective, if they're going to be sponsoring you for a green card and paying all of the fees associated with that, and they just recruited you and they paid a lot of money to recruit you, they paid a lot of money for your immigration process, they may not be like super excited to start the green card process for you before they get to know you a little bit and have a feeling for whether you may be committed to staying with them for a while, or knowing that your employment with them is going to be working out. So they may want you to work for some trial period before they start that process, just to make sure everything's okay. There are other employers who will do whatever you want and start that process anytime. That doesn't make those employers good or bad. It's just they have different policies, the same way they have different employee policies on a lot of different things. So they can start at any time, but that doesn't necessarily mean they will. I think I might have hit the last question.
Okay. I don't see any more on my end. You covered them all. So I just want to say thank you for everyone attending. I just saw a question pop up, so I'll pause on that. It's in the chat box for you. For J1 waivers right now, I don't think the government shutdown is going to have a huge impact. If the application, if you're filing with a federal agency like HHS, hopefully the application can be filed before then. But if they shut down and the application is filed on like November 1st, nothing is really going to, nothing's going to happen during that time. So, on J1 waivers, there's not a whole lot that needs to be done far in advance in the event of a government shutdown. As far as I can think, the Department of State's online portal for filing their application will remain open. And like I said, if you get an application in and the agency hasn't looked at it yet, it's going to sit. Now, for the Conrad 30 waivers, shouldn't be a problem because they're all state agencies and they should be totally unaffected by a federal shutdown as far as handling these waivers. So that shouldn't be an issue. Okay. Is there any other questions tonight from anyone? Okay, if there is no other questions, I just want to say thank you all for attending tonight and thank you for your time for presenting this. All right. I hope you all have a good night, everyone. Bye.
Bye.